I've actually indeed been involved in an effort to produce a constitutional project, a grassroots constitutional project, done mainly by people who reside in Russia. So this is not my project, it's a collective effort. But today I'm going to address a number of questions that go beyond the specifically Russian experience. Let me only remind you about the project of so-called social contract of the autonomous administration of northern and eastern Syria, so-called Rojava region, on the one hand, and on the other hand, efforts that were already mentioned within the framework of this conference related to a number of projects developed by Chilean activists throughout the last 10 years or so. What somehow combines all those efforts is the question about the possibility of public consultations, both as a method and as a framework of developing what is in a Rojava project called a moral political society. So this is exactly this predicament of transferring or translating ethics into the domain of constitutional process, into the domain of constitutional making that I'd like to address. And I'll start with the reference to Marsilius of Padua. Unlike Aristotle, Marsilius claimed that there is no fundamental likeness between citizens. So in terms of governance and the overall structure of society, we have to deal with all those citizens who lack moral excellence. Not all citizens are indeed morally excellent, and we have to accept this fact. We also have to accept the fact that differentiations in the society are very much important in terms of coordinating consent. Now, with Marsilius somehow weakening the standards or the conditions of a previously famous conception of common good, we're sort of coming into the realm where capacities, intellectual, rhetorical capacities of citizens have to be developed in a process where no one is by default granted moral superiority. We can obviously address this through the idea of civic education. So indeed, some kind of civic education of what is called yesterday civic virtue might be needed or still is needed. However, it is not always a workable option. Sometimes you have no time for that. Sometimes you have to sort of combine civic education with the actual process of constitution making. So in a way, civic education and civic virtue is an option, but it is not an only option. And sometimes people who have no or less civic virtue still participate in the process of constitution making. So my question here is how to go with those people who are not civically educated or less prepared to understand their job within the process of constitution making in terms of civic virtue. Agents that are less than morally superior or simply sometimes immoral. Now, before that really challenging conversation, it is necessary to mention that Constitution itself largely is being largely understood as a kind of another law, namely the law that limits those laws that are enacted by people in power. And that is why the Constitution protects or is considered to protect freedoms. This is more or less standard liberal interpretation. And the idea of limiting power is also at the heart of the creation of constitutional artificial intelligence. So these days, when we're talking about producing constitutions for less than morally superior agents, we have to take into consideration the fact that not only human agents are on the boat, also non-human or more than human agents are very actively present in this whole project. Well, these limitations or these possibilities are undertaken not to protect freedom per se, but also to limit possible harm to users, which may indeed limit their freedom and interaction. So a constitution, in a way, follows a state of affairs in which the distribution of strengths and distribution of parties capable of causing harm and also parties that are in need of defense is very dynamic. It is constantly changing. It is not as if like they are some powerful humans and less powerful humans. It might be, for example, also the case that all humans are less powerful than non-human or more than human agents involved in the process of constitution making. So in a way, any constitution have to ensure that the strongest party is weakened. That's the predicament. How to weaken the strongest party in the process of constitution making. This has to do a lot with constitutional dilemmas, because the complex nature of this constitutional project, the process of weakening the strongest party, is showing us that the Constitution really works as another law also in relation to itself. And there are several important dilemmas, for example, minority and majority dilemma. Constitutional designs for humans are normally based on majority rule, and the Constitution sometimes helps to form the majority. Simultaneously, the Constitution explicitly enshrines and recognizes minorities' rights, as well as providing them, these minorities, with special rights or privileges or advantages. Furthermore, the constitutional protection of minorities' rights and interests may differ from the majority interests, at least in some ways. Thus, the constitutional process necessitates creating opportunities to protect the interests of the majority, while not infringing on the interests of at least some minorities, even if it means creating some tension or conflict between various constitutional provisions. And indeed, there's an abundance of examples of these inner tensions in constitutional texts. American Constitution, Russian Constitution, Chilean Constitution, whatever. Now, the second dilemma is the tension between ordinary and extraordinary. Constitutional provisions, in the sense of the very notion of the main or basic law of the state, must be stable, resilient to political turmoils. A constitution helps to resolve political crises, but it also produces political crises. So in a way, constitutional texts manifest a kind of dual temporality. They're always relevant, and at the same time, they're always distanced from the changing realities of political landscape. And a constitution plays, so to say, a twofold role. It is preserving business as usual, and it also provides a means of challenging the ordinary and the fundamental conventions. And finally, there's also a dilemma of rules against corruption and corruption because of rules. Now, the status of a constitution requires special forms of its protection, and any constitution must be protected and safeguarded. However, the protection of constitution may be monopolized by an unaccountable authority, thus safeguarding the fundamental values and principles of a certain constitution serves as both the highest virtue and a necessary condition for the corruption through and under the pretext of those very rules. A constitution somehow presupposes the requirement of special legal protection and also create provisions to acts that goes contrary to the provisions of that very constitution. The constitution establishes a requirement and an incentive to break it for the sake of safeguarding constitutional order as a whole. Now, at that very point, we arrive to the question of freedom, because the protection of freedom or freedoms in the constitutional project, just like any other fundamental provision, is a variable amongst other variables determined by the composition of the circumstances in which it is substantiated. And one can reasonably ask, should we actually rely on a particular definition of freedom while trying to make efforts to produce our constitution? Now, there are different cases when constitutions are produced. There may be, for example, produced after the war, so as jus post bellum. And of course, there might be different constitutional projects that are produced as viability tests. So, for example, when colleagues from YGRIC suggest to have this council of F4s, they're definitely putting this idea on a viability test, regardless of the fact that this test is so far limited to the field of academic discussion. But also, constitution is definitely a number of rules to build sustained compromise. Now, how weak people or weak parties can build a compromise with those who are more powerful? That is one of the questions that has to do with exiles and migrants. We've talked about that yesterday, but also with constitutions that are produced in less specific conditions. The realization of constitutional project only in the spirit of constraints imposed on the strongest body turns out to be, in fact, an acquiescence to the already existing distribution of power potentials. Such a constitution, so to speak, produces freedom by providentially subtracting the possibilities for arbitrariness. And this approach imposes restriction on realization of power at a time when it has not yet been created, or when it is in the process of formation. How can the constitutional process be realized in a situation when power has already been consolidated and the apparatus necessary for the realization of arbitrariness is already in place? Should we count on a benevolent ruler who will willingly limit herself or himself or themselves? Should we count on a popular uprising? Well, we have these possibilities on table, but I'm going to present an alternative related to the organization of the process of constitution making per se. And in order to make this, I'm going to refer to classic contribution on the idea of freedom produced by Gerald McCallum. Now, McCallum is saying that freedom is a sort of triadic relationship. Who is doing for what purpose, under what circumstances? So any viable definition of freedom, according to McCallum, is a definition that follows this triadic formula. In light of this idea, the movement towards compromise then begins with the formation of a list of agents, conditions of activity, and goals. Who has the possibility to do what, under what conditions, and to achieve what goals? This seems to be a technical work. However, this is a starting point of crystallizing freedom under authoritarian conditions. So, in this case, we're not engaging into ongoing discussions who actually has the right, the moral right, to participate in this process. we're just putting our lists of agents, actions, and goals on table one by one. It can be assumed that with respect to some goals, there will be a fundamental agreement on permissible or impermissible actions, or there might be a disagreement. If, however, at the stage of constitution making it is still possible to form such a series of triadic relationships, it can be considered a success per se. Compromise at this stage manifests itself not so much as an agreement on any particular goals or types of actions, but in the very act of following a uniform order of disclosure of goals and actions by different agents. In this phase of the constitutional process, it is not even necessary to speak of drafting the Constitution as a separate text, because what we're doing here is just merely disclosing our interests. Constitution making, in this case, takes the form of constituting over a certain way of describing goals and actions, or, to put it differently, of explaining competing understandings of freedom. Once this formal compromise has been realized, in other words, when the agents, the types of actions and desired goals are presented, it is possible to compare the expressed priorities and to start a meaningful discussion of possible compromises. The consolidation of common goals and shared types of action. Again, it is possibly but not necessary that already at this stage the preconditions for a fundamental agreement on certain principles would become apparent. However, given that this process of identifying meaningful compromises may take place in a non-democratic form, seeking to secure fundamental agreement at this stage would only lead to collusion among the most powerful forces. Therefore, at that stage, freedom is still discussed in this triadic logic, so simply presenting what agent is doing what to achieve what purpose. Only after meaningful compromise on freedom in the above sense of identifying agents, actions, and situations, types of goals, as well as identifying points of convergence, has been formed, it is possible to proceed to the actual drafting of the constitutional text. So constitutional texts are not made from scratch. They presuppose the fixation of certain conventions or provisions in a form of, I guess, more or less apparent convergences and compromises. So the non-liberal constitutional process is structured as follows. Yeah, this is the wrap-up of McCallum's idea. And now to non-liberal constitutional, the structure of this process. So first we have formal non-democratic compromise on the order of representation. So all parties that are taking part in this process agree to accept this triadic logic. Agent, type of action or situation, and goal. There's the second stage is substantive non-democratic compromise, identification of common types of action and shared goals by different agents. Now, only after that we can arrive to a stage of conditional democratic compromise on the structure of the provisions to be included in the constitutional text, and then substantive democratic compromise on the shared and rejected goals and types of action. So to conclude, I've been trying to present an argument about a good enough constitution, or in other words, a constitution that could be made under the substantial external limitations, although those limitations related to the fact of authoritarian government. An important boundary condition of this whole argument was the desire to relate this to specific conditions of more or less authoritarian regimes. Certainly these regimes already have constitutions, and they have already established themselves in one way or another. So a new constitutional process under these conditions cannot be presented as a revival of pre-existing democracy. Still less can it be a business as usual of drafting yet another constitutional text. So, in a way, that kind of constitution must be defined as not as an artifact, not as a text, but as a process of identifying another law in the structure of making compromises, trying to find common ground between the agents that are not morally superior and, in fact, are not very much interested in limiting their powers at the first place. This is it.
Yeah, thank you very much, Piotr. It's really very interesting, and I see why and where you are getting with this. What you presented sounds like a Madisonian solution, basically the ad hoc structure to reconcile interests through checks and balances, etc. And the premise of such a solution is the idea of an interest. It's basically a constitution of interests. I mean, largely speaking, this is a liberal approach, even though like a specific liberal approach. We discussed over the table yesterday what different meanings liberalism could have, but this is certainly one of them. My worry is that if you institutionalize a constitution based on interest, then it is the interest that you will get as an effect. That's the basic philosophical problem with this kind of liberalism. That it, by taking interests into account, it preaches self-interest. And when we had more or less such an understanding in the law and political science in the post-Soviet Russia, the cultural and psychological effect was precisely this. People learn to be cynics from the institutions built for cynics. It was not only constitution, of course, but mostly the neoliberal economics. But there is this kind of non-obvious vicious circle here, which for me is a great defect of any liberal constitution. That's why I'm in favor of a republican constitutionalism.
Well, first, there's the difference between interests and freedoms. So I've never been talking about interests. I've only been talking about how to translate somehow cynical idea of interest into the idea of freedom. This is actually the core of my proposition. So no talk about interests, only talks about freedoms. And this is actually the inherent vice of Soviet experience, because they were indeed talking about their interests without actually knowing what their interests could be. Because red directors, party bureaucrats, whoever, just as any other Soviet citizen, had no experience of capitalism whatsoever. Now, secondly, in terms of liberalism and non-liberalism, there are indeed lots of definitions of liberal and non-liberal, yet I've been trying to, somewhat vaguely maybe, to address the fact that for liberalism it is important to have this idea of limiting the power at the core. What I've been trying to put forward is that constitutional process actually starts not with limitations, but with openly disclosing whatever I want. I want to kill like 100 million people on Earth. Great, let's put it on table. I want to use nuclear weapons. Great. I mean, I'm just exaggerating, but this is a very different idea, and this stands in contradiction to what Madisonian compromise looked like, as they indeed were trying to find the common ground from the scratch. This is not what I'm saying. I'm saying that we have to accept the fact that it won't be possible to find this common ground, at least at the initial stages of the constitutional process. And this is indeed what is actually taking place right now, even in the Russian opposition leaders, right? They're not able of finding any common ground. But yeah.
Well, just an immediate follow-up. If you cannot find common ground, you're not taking anything off the ground, right? So, and the Madisonian, how do you reconcile slave state and non-slave state? Good luck to that, right? I mean, it's not like their interests were particularly overlapping. It was a very hard negotiation at that convention that took 6 months, right?
Accepted, yeah. Let's also accept the fact that there is a difference between substantial agreement and formal agreement. So the difference between what we're going to do and how we're going to do. To put it plainly, my idea is that effective constitutional process starts with the question of how. How we're going to discuss also even the fact that our interests are like way different. And only after that we arrive at the question of what. So this is...
So procedures first.
Yeah, procedures...
Very liberal.
Procedures goes first, but these procedures are not... Well, we can dispute that. I would say that not necessarily... I don't see any a priori reason to talk about procedures in a necessarily liberal way. Maybe you can challenge me on that, but that's, yeah.
Just wondering, because this is something that has been on my mind yesterday as well, discussing the questions of constitution, constituent power, I mean, a wider sense. But it seems to me that we're discussing only a constitution of one nation, right? And this, I mean, not one specific, well, also one specific, but
One state.
of one state, yes. Of one people, yes. But, I mean, is it really so idiotic to even assume that maybe why shouldn't we discuss global constitution? Is it like, I mean, the institute is called Institute for Global.
Yeah, it's an ambition.
Right. We haven't, I don't think we have really discussed this yet.
Yeah, that's a good point. And indeed, well, at the very beginning of my talk, I've been referring to the experience of Rojava, this Kurdish autonomous administration. What they're doing actually is indeed trying to bring on one table people coming from vastly different backgrounds, although on a limited territory. So your question actually hits the point of my interest in non-liberal constitutions, given the fact that in Russia, just like in Rojava and many other parts of the world, we do have lots of people who are acting according to Sharia norms and other kinds of, put it broadly, non-liberal, but still lawful institutions. So the very idea of constitution as another law, in my perspective, paves the way for discussing this as a foundation not for only nationally bounded projects, but also for projects that goes beyond national borders in whatever sense.